May I please, your lordship, unless the mention for today itself from bail hearing motion, lordship. Bail motion, lordship.
For today,
Lordship.
is it urgent?
Yes, lordship.
Section involved?
379 and 34.
Okay.
Obviously.
May I beg your lordship? Lordship, I would like to mention item number 24 and 25. I have taken consent from the petitioner's side, your lordship. Matter may kindly be adjourned for today, your lordship. Fixed in the supplementary.
24 and?
Your lordship, I'm for the petitioner.
I've taken the consent.
Okay. You're for the?
Petitioner, T.
You're for respondent.
Yes, sole respond. T. Sering.
You have no objection.
No, your lordship.
Okay.
Your lordship, humble prayer, lordship. This matter may kindly be fixed on 27th of May.
27. Okay. You are Mr.
T. Sering, lordship.
T.
T. Sering.
For the respondent number?
For respondents, there is only one.
Sole respondent.
Yes.
Okay. Okay. Her Miss
M. Yaram.
Land counsel for the petitioner and Mr. T. Sering, land counsel for the respondent. I prayed for by the land counsel for the party. List this matter on 27 is okay.
May.
27 of May.
27 May.
May.
And your lordship, this interim order may be continued.
There is interim also.
Yes, lordship.
Okay. The interim order passed earlier shall continue till then. Okay.
Deeply obliged.
May I please, my lord?
Yes.
My lord, I beg to mention item number 9, my lord. On behalf of tea time,
Yes.
I have taken consent from the petitioner side, my lord. Matter may be kindly adjourned today.
Item 9.
Yes, my lord.
I am for the petition. You are for the petitioner. You are for?
I am for the respondent, my lord.
Respondent.
On behalf of tea time, my lord.
Yeah, probably you had to file affidavit in opposition.
Yes, my lord.
Seeking time.
Yes, my lord. Kindly three weeks,
Mr.
three weeks with time may be given.
Petitioner. And also heard Mr.
M. Doji, my lord.
M. Doji, who prays for
Adjournment of-
granted 3 weeks time
Yes, my lord.
to
3
file affidavit in opposition. This is matter after 3 weeks. Okay.
My lord, there is an interim order.
There is interim order. The interim order passed earlier shall continue till then. Okay, till the next date. No. Okay.
My lord, I have another mention, my lord.
Yeah.
Item number 18, 19, 20, my lord.
Okay. You are for
I am for the
petitioner.
petitioner, my lord.
Okay. So when do you want,
After 2 weeks, my lord.
Mr.? You have taken consent from the other side?
Yes, ma'am.
Okay. Mr.
M. Doji, my lord.
Land counsel for the petitioner, prays for on the consent of the other side. Prays for listing this matter after
2 weeks, my lord.
2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Obliged.
There, my lord.
Yes.
I beg to mention item number 21 on behalf of K lawyer with the consent from other side.
On behalf of
K lawyer
K lawyer.
for respondent.
For respondent.
Yes.
Who is for the petitioner?
Petitioner Ricky Bang.
You have taken consent?
Yes, my lord.
Okay. When do you want?
After 3 weeks.
After 3?
Yes.
Mr.
P. Harming. Punyo
Appearing on behalf of K lawyer, Land counsel for the respondent
21.
on the consent of the Land counsel for the petitioner, prays for listing this matter after 3 weeks.
3 weeks.
The prayer is allowed. List this matter after 3 weeks. Okay.
Deeply obliged.
My lord. My lord, I beg to mention item number 3, my lord, on behalf of L. Kurdu.
Crossing petition. On behalf of L. Kudu.
L. Kurdu. My lord, matter may be listed after 4 weeks, my lord.
Why?
My lord, since leading counsel is out of station,
Okay. Mr.
you
You are Mr.
NUB.
Appearing on behalf of L. Kudu. Sorry. Your N.
NUB.
You be Land counsel. Submits that the main counsel appearing on now counsel for the petitioner, Mr. L. Kudi, is out of station and prays for listings this matter after
4 weeks, my lord.
4 weeks. The prayer is allowed. List this matter after 4 weeks. Okay.
Obliged, my lord.
Mayor, my lord.
Yes.
My lord, I beg to mention item number 16.
Yes.
The joint petition, my lord. On the last occasion, LCR was called.
Passing petition.
Yes.
What do you want?
Adjournment for the day. The leading counsel is out of station.
You are Mr.
C. Natum.
for the petitioner
Yes.
appearing on behalf of Mr. Who is leading counsel?
B. Arun.
B. Arun. Sami says the leading counsel, Mr. B. Arun, is out of station and prays for adjournment for how
4 weeks, my lord.
adjournment stop as prayed, comma, list this matter after 4 weeks. Okay.
Mayor, Your Lordship,
Yes.
I beg to mention item number 22. I am appearing on behalf of T. Bakang. Your Lordship, as per the order dated 01/04/24, the matter should be listed after 2 weeks, but it is mistakenly today it is listed. So matter may be listed accordingly, Your Lordship.
When do you want?
Your
Uh,
Lordship, for the claimant in this case, if it can be listed on the 23rd of April.
23rd
Yes, Your Lordship.
of,
April, this month.
you agree with that?
Your Lordship.
Okay. Or Mr. You are Mr.
T. Numa, Your Lordship.
appearing on behalf of Mr. P. Bagam, land counsel for the appellant, and Mr.
VT Gurung, Your Lordship.
land counsel for the respondent claimant. So is prayed for by the land counsel for the parties. List this matter on 23rd April. Okay.
Deeply obliged.
Yes.
My lord, item number 10 or something.
Yes.
I am for the petitioner, man.
You're for the petitioner.
Yes, ma'am.
What you want?
Not actually, I have raised the question of maintainability. It was to be
Item 10.
Item 10. So since Mr. Tang is absent, it came call. But on the next day, within observation, the question of maintainability shall be taken up.
So earlier, whether this observation has been made earlier in the earlier order? No.
No, not that observation is not there.
So
So this-
when do you want?
after
After
2 weeks,
2 weeks.
my lord, it may be listed on 26 then.
Is it okay?
Yes, my lord.
26/4.
26 for.
Or Mr.
M. Doshi, my lord.
appearing on behalf of
T.
Mr.
Tang.
Land counsel for the petitioner. Also heard Mr. T. Patil, land counsel for the respondent. Staff. Is prayed for by the land counsel for the parties. List this matter on 26
26 for.
2024.
The question of maintainability.
On which date the question of maintainability shall be heard. Is it?
Of this is civil revision petition.
Okay.
Obliged.
Possibility of the civil revision petition shall be heard. Okay, considered, shall be considered. Okay.
May I please, sir? I'd
Yes.
like to mention item number 17.
Yes.
In this case, I'm appearing on behalf of Mr. S.K. Deori for the petitioners. And so according to the file noting, service on the respondent is still awaited. So this matter may be fixed after 2 weeks.
Okay, we'll pass order when the matter is called. Okay. Calling it. Okay. Yes.
May I, Lordship?
Yes.
This is a joint petition file under section 482 for the quashing of GR case number 187/21 and subsequent proceeding relating to this case.
So in this, it's a joint petition.
Yes.
And here means petition number 1 and 2 are the alleged accused, and petition number 3 is a lone single victim.
Yes.
So allegation is under section 323, 342, 506, 341. And may I read this FIR?
Yes.
FIR type copy is in page number 19.
Hmm.
After subject, I'm just going through the body. With regards, I am to state that all alleged accused person here and mentioned above has committed the above subject offense against me on dated 12/03/2021. That the fact of the case is herein understated as that I, along with my wife,
This FIR was lodged on
law zone,
16/3.
yes, yes.
Whether the accused was arrested.
Accused, it's a bailable offense, so arrested and they appear before the IU and subsequently they were released. Yes.
Bailable, why don't you go to the trial court?
Yeah, Lordship,
The Lok
yes.
Adalat?
Lordship, it's not,
Bailable is bailable as well as compoundable.
yes, sir.
Then why don't you go there?
Lordship, it's still in police station only, matter is still with police station, still not charge sheeted.
No, no problem.
Lordship, there is a apex court judgment also that for the exigency, they can approach this honorable High Court for quashing of any criminal proceeding.
Immediately on the next Lok Adalat, you can just request the Lamed judge to place it before the Lok Adalat. If the parties are ready, parties are ready.
Parties are ready and
Then-
it's already
then what's the
settled.
problem? What is the problem? Then,
Thing is that the one party, this victim reside in Sagali right now.
that is why.
That's why it's difficult for them to sometime to fix that date. And apart from that, recently, last, not this one, previous Lok Adalat were cancelled due to the PO on leave.
You can settle. You see, there used to be a sitting, pre-Lok Adalat sitting. In that you can settle, and in the day of Lok Adalat, the other accused are also there. It can be automatically settled.
Lordship,
Now, whether in the High Court, is it maintainable?
yes, maintainable. Just
Where?
I will. It's I will share. This is one judgment by Apex Court, and I will apprise this honorable court.
Things are easy, you see, if the parties, the case is
Yes,
available,
it's
compoundable.
yes.
parties,
Paragraph
then no
1.
problem. Then what problem, huh? What
Lordship.
urgency is there?
Urgency is that it's been more than 3 years, and this one of the alleged accused, petitioner number 2.
When the consensus or mutual agreement entered into between the parties?
Yes,
Now, when?
it was entered in the in 2013 February, last year only.
13 or
It's
2020?
more than 1 year. Yes,
23.
yes. So it's more than one year. So it's still.
When this was filed?
It was filed on this 13 of this previous month. Because this party thought they will approach this, once the charge sheet is filed, then they will approach the presiding officer for Lok Adalat. But still that charge sheet is still awaited for last 3 years. So paragraph 1 and paragraph 15.
If the charge sheet is still awaited, that means it is still under investigation.
Lordship, once we approached this PS, then they stated that we had filed the charge sheet. But according to record in GR, that still it's not received by the GR branch.
If it is still under investigation, can't interfere.
Lordship, it's according to PS, it's been charge sheeted, but still it's awaited there in GR branch. So for the clarity, this honorable court may call for this record also, whether it's charge sheeted or not, or
Status report not called for in this case, in the earlier order.
no. In earlier order, this is for motion. In earlier order, there was some confusion whether this court has whether this petition is maintainable or not. So in this BS Joshi and others versus State of Haryana and another 2003 for SCC 675, where in paragraph 1, if for the purpose of the securing the ends of justice, quashing of effort.
It is not a case where the incident did not happen. It is a case where the incident happened, but since it is compoundable, it can be settled.
And relevant paragraph is paragraph 15 that Philip is over there. And subsequent practice in other high court also. There are 5 more judgment of the other relevant, means parallel high court, where in same type of cases has been quashed by other high court based on the compromise and settlement been come up.
What I'm saying, there is not a case that the incident didn't take place. So and since it is compoundable, the Lok Adalat would be the best forum. Then again, you see, we need to see, unless we see the police status report, we can't. We have to call again.
Yes, Lordship, then record may be called this from this.
It's always better, because how do we quash? You are not saying that incident did not take place.
No, incident didn't happen actually. If that settlement deed is there, Lordship, settlement deed is there.
Settlement also it appeared. What the settlement says.
Yes, settlement in petition.
It is admitted fact, I think. The fact.
In petition, that mutual settlement deed is in page number 21. 20. Page number 20. 21. The fact of the case is that actually, whereas the brief background of the fact is that on 12 March 2021, this means victim, victim has visited the residence of the alleged accused petitioner number 1 to explain the allegation regarding the illicit relationship with the wife of the petitioner.
Because of that, the incident took place.
Lordship, there was no incident. Actually, this victim, there is one 376 trial is going on and before this session court against this victim. So victim has,
Against this victim.
yes, victim has their family
Commission of
relatives.
Offense against whom? The
Victim.
Present victim.
Yes,
No, the victim means the informant.
yes.
Okay. So saying what? He has committed offense against whom?
Against the wife of petitioner number 1.
Okay, there. The
Yeah.
case is pending before the,
Yeah, session court.
okay.
376. So in that regard, this person, victim, has lodged this false FIR, actually, just to mitigate. Therefore, they had settled down this, and this case is still,
Need to call for record.
okay, law,
Hmm.
yes, record may be called.
So, yes,
Yeah, Lordship. If the charges has not been,
not yet submitted.
there no CD may be called for, Lordship.
Scan copy. Okay. Hard. Mr. P. Kipa. Then counsel for the petitioner. Also have Ms. H. Lakshmi, Lanet, additional PP. Staff. The code was not called for.
Lordship, the earlier this dispute was there that the sections are all compoundable. So it is maintainable or not, Lordship.
Lanet, additional PP submits as the case is still under investigation. This was 2000?
21, 21,
21 K, 21 K.
yes, Lordship.
Call for the scan copy of the case study. The Lanet additional PP shall also produce the status report of the case on the next day. List is made after. Which case? Which place?
Bandada PS,
Canada.
yes.
After 2 weeks.
The previous was with election.
Okay.
Yes,
After
after
3 weeks. Okay.
highly obliged.
Apply.
Yeah.
Yeah, please, my lord. My lord, both the parties amicably settle the matter.
Hmm?
Both the parties amicably settle the matter. We'll file joint affidavit on the exit. My lord may fix a short date for the file.
What is this matter about?
For dispute over the 8 number of quarters, you know.
Hmm?
Disputes over the 8 numbers of quarter of Arke Mission Hospital.
Okay. So.
Both the parties amicably
if it is
settle.
settled,
Yes.
You want to withdraw?
Yes, no, my lord, we'll file joint affidavit
Okay.
on next date. My lord may fix a short date.
Okay. Heard, Mr.
They,
D,
DEY,
Planning Council for the appellant.
appellant, my lord.
Also heard, Mr.
L. Nara, for the respondent.
Okay, L. Nara, Planning Council for the respondent. So, you are aware of the settlement?
Yes.
Okay, the Land Council for the party submits that the matter has amicably been settled between the parties out of court. And you want to place, and praise for some time to file joint affidavit.
Joint affidavit, my lord.
Along with that,
Uh,
there is some agreement, enter into some, executed some agreement, etc. Okay,
yes.
no problem. To bring on record, stop, the prayer is allowed, list this matter, not bring on record, joint affidavit, the prayer is allowed, list this matter after. what date?
After 1 week?
After a week, okay. After a week, it would be, no, after a week would be only 19. Okay, okay, after a week.
All of them, my lord.
What happened, three finished, okay, okay, John, okay.
Oh, Lordship, the service has not completed yet.
Four,
Lordship, upon response number 2, Lordship.
I have been languishing there for more than 210 days.
what is the offense?
Offense, it is under 363 of IPC and 376 clause 2 and 506 and 34 of.
Let us see the FIR.
FIR is on page number 15. Annexure 2. May I read the FIR?
Hmm,
And the applicant is the father of the victim. He has been authorized by the judges.
okay,
Authorization is in page 4. Okay.
okay, yes, yes, okay. So case diary, CD was called for.
Yes.
Hmm.
Your,
Charge sheet already filed.
yes, it's a,
Case diary, CD or case record?
Lordship, LCR, Lordship.
LCR,
Lordship,
okay, charge sheet already filed.
Lordship.
So charge sheet under section,
it is in evidence stage, your lordship.
evidence stage.
Yes. And they are not appearing before the Lana trial for the
Who are not appearing?
complainant and the victim. They are not appearing. For they have been summoned more than 5 times. They are not appearing. So
Have you applied bail for in the trial court before the
yes,
trial?
yes, I have, but my bill
Rejected.
was rejected. Yes.
Okay, then. So
This is
on what ground it was rejected? Have you annexed the bail order?
yes, yes, I have annexed the bail order. It is in annexure 4 and page number 21 of my petition.
Annexure page 21.
Yes. Yes, 21. I have applied for default bail.
Hmm. And thereafter, have you applied for
Yeah.
the regular bail?
No, your lordship.
Why don't
Thereafter,
you apply there? The trial court would be the best person to know whether the accused needed to be released on bail or not. Hmm?
your lordship, that is there, but
376?
yes,
On what ground you're asking, seeking bail?
you know, your lordship, the allegation is false. I mean, they have, we had some altercation on our journey. Just to take vengeance against me, they have lodged a false.
Vengeance for what?
I mean, we have some altercation and I have ordered, I have, directed them to unboard from my truck. So that is the
No,
reason.
no, that is not the. See, the FIR and the statement, 161 statement also. The victim and the informant has been consistent in their statement.
Mm. But then statement, it can be
You just see, read the FIR and also read 161 statement, it's all the same. The statement of the wife and the husband also. It's all the same.
Yes, Your Lordship, but the statement, it can be a substantial piece of evidence. So, I mean,
So, and the finding of the finding thereafter also. What is the report?
report
If it is a false, whether the victim was examined by the doctor. Have you seen?
he was examined and FSL report was awaited, Your
Awaited.
Lordship. Yes, and without,
Do you have the medical report also? Copy of? No.
no. Yes, but I have not annexed in my application.
Deposition of an additional PP. So just the medical document.
Your Lordship, I already filed, my bail was rejected. I have already filed bail under 439 in the session court.
Okay.
I'm sorry, I was
Rejected.
mistaken.
On
Yes,
what ground?
it was rejected.
The Lordship, their ground was to Lordship for the default bail, Lordship. But it
Default
was
bail-
not considered, Lordship.
Default bail have rejected.
Before as well as yes, 439.
439, on what ground it was rejected?
It was rejected.
When it was disposed of?
19/12, 2023.
Okay,
Yes,
so by then, the charge sheet already filed.
yes,
Okay.
charges has been filed and
It was considered on merit and rejected. After consideration, it was rejected, isn't it?
yes.
Okay, what is the new ground you have taken this time? Your
This
bail was
allegation is
rejected-
false.
Your bail was rejected on default bail as well as on merit.
Yes,
So what is, what new ground you have taken?
this allegation is false, your Lordship, and
The Landed Trial Court has also
if,
considered that.
if it was true, they should have appeared before the learned trial court for examination of witness, but then they are intentionally avoiding the summon, your Lordship.
So
And
now you see the court has the power to issue summon, then bailable and non-bailable warrant if they fail to appear. If they are in the station, if they have already moved out, could not be found out, that is different case.
it's your Lordship.
That cannot be the reason. If there is a prima facie, if there is a case, and trial has already begun, the handyman has also given statement, and then it appears that when the statement of the handyman or the deposition of the handyman before the
Yes,
court in its evidence also appears corroborate the statement given by the victim and the informant under 161 as well as 164 statement. So
but there is a presumption of innocent until proven guilty, your Lordship, and
that
the
is
reason
there-
I'm
there-
the reason I'm here before your Lordship is now if I'm enlarged on bail, I have the opportunity to contest my case fairly. That is the reason I'm here, your Lordship. And if I'm the sole breadwinner of my family. I have a minor daughter, a wife, and a mother. They are on the verge of starvation because
why should you commit that?
I have
From the very beginning, you have been torturing these two, this family, wife, husband, wife, and one son.
I have not committed the offense, your Lordship. This is a false allegation against me.
You are co-accused. He should have been made co-accused, but then he has not been made co-accused, handyman. He himself stated after the wife got up in the vehicle,
Yes,
he closed.
but yes, that is,
Only he avoided the portion of the commission of the offense.
yes, that
The
is
rest
there.
is all the same.
That is there, but your Lordship, it can't be considered as a substantial piece of
That is a
evidence.
Prima
He,
facie case for the purpose of considering bail. That will take care of by the trial court, the evidence part, okay? But then prima facie before this court, for the purpose of considering for granting bail. So where is the medical documents? I'm looking for the medical documents.
Lordship, I have not
Is it
gone
there?
to the Lordship, LCR yet, Lordship. Lordship, may I submit,
Or
Lordship, Lordship,
whether the victim was immediately taken to hospital for examination.
Lordship, may I, Lordship, Lordship, this is come under 439, Lordship, for the bail, Lordship. For here, Lordship, in the 439, clause 1, subclause 1A, Lordship, the presence of informant or any person authorized by himself obligatory at the time of the hearing of the bail application.
Not made party.
Lordship, here,
You have not made
service
party
upon
to the
respondent number 2, Lordship, is still awaited.
yes,
Oh.
in the in the earlier, I mean, before this, I have filed one bail application before this honorable court. And
Appearance of respondent number two, the victim is also necessary.
Lordship,
So it's still awaited. I was thinking. of
Lordship,
yes,
that's why
yes.
Lordship, I'm sorry.
Still awaited. Can't consider also at the moment in absence of the victim.
yes, yes, that is there, your lordship, but however, I have been languishing in jail for more than
Ah.
200, more than 200 days.
That's true. But then what can we do? We can't change law.
Yes, so that
The
may
law
be
says
given
it.
in that,
Okay.
in that regard, so that may be given, your
So
lordship.
if
So,
the victim and the informant are still there in that address.
your lordship,
Mr. Lordship, service may be issued, Lordship, by the officer in charge of the concerned PS,
Okay.
Lordship.
Miss A. Talam,
Talam.
Land Counsel for the petitioner. Also had Miss L. Hage, Land Additional Public Prosecutor for the state of AP. So, you thi- in view of the office note dated 8/4/2024. The Land Council for the petitioner prays for some time, some more time to take fresh steps upon the respondent number two. The prayer is allowed. When do you want to list this matter after 3 weeks?
No, your lordship.
2 weeks.
After election.
After 2 weeks then, stop. In the meantime, the petitioner shall take steps upon the respondent number two by a registered post with AD.
So to the concerned
Bro-
PS, Lordship, because
Okay,
Lordship,
okay, okay.
AD is not.
Take steps upon the respondent number two
Mm,
through the OCPS concern.
Lordship,
Okay. You take steps.
obliged, Lordship.
Yes. Yes.
May I please the lawsuit?
Yes.
439 bail application, my lord.
The
It has been
LCR was
fixed,
called for, Lordship, it's still abated.
Communicated by memo, and so. Not arrived,
Not Lordship,
not received.
not Lordship.
No, my lord.
It's called by
I
the
will expect
registrar.
your submission, your lord.
Yes.
Lord, statutory period has already been completed. As on today, 181 days, your lord.
Hmm.
And all the other co-cases has already been granted bail by
What
on a
is
trial.
the
court, my lord.
allegation?
Section 20C
Offense?
and 25 of the NDPS Act.
Okay.
So,
23,
my lord,
20, B or C,
20C, my lord,
20C,
20C, commercial quantity.
commercial.
Yes.
Then how many days?
60 day, 6
60
months,
days,
180 days. 180 days, my lord.
180
As on
days.
today, 180 days. Today,
Today.
181.
No charge sheet.
No such in file.
Then you file one miscellaneous application on for default bail then.
My lord,
Then if you think that he has completed the statutory period,
my lord, my lord.
then you file one application with IA
Yes, my lord.
that he has completed the statutory period, no charge sheet filed.
Yes,
That will be considered.
my lord. The court will go to on vacation, my lord. I have a submission. If your lordship is that direction may be given, my lord, that line of trial court will consider the bail if there is no such result.
No need, even if you file before the, okay,
Court will go on vacation, my lord. on-
charge sheet not yet filed. Miss Saki, no. Charge sheet not yet filed.
Lordship,
You have any instruction?
no, Lordship, we have called for the LCR, Lordship.
LCR.
LCR then Lordship charge.
NCR means that means charge sheet
Your
already filed.
Lordship, it is also file, Lordship.
Last occasion, CD was available and
No, if LCR has been called, no, it is CD, relevant CD,
Oh,
Relevant
Lordship.
CD.
not CD,
Then
not
what-
LCR.
CD was, on the last occasion, the CD was available in the court, my lord.
Lordship,
Yes,
sorry,
it's very
because
well
on the last
documented.
occasion,
Last
Lordship, some other additional PPOs appeared, so I have not idea,
No,
Lordship.
last case there was also produced in the last occasion, not
Called
LCR.
for the
It's
CD,
listed.
Lordship, yes, Lordship. It was called for the CD.
Now you also obtain instruction
No,
the
sir.
next day. if they fail to produce case diary based on your instruction that
Yeah.
whether charge sheet filed or not, the matter will be considered. In the meantime, you can also file. And if you think, no. Yes.
Quickly, sir, another bill,
Okay.
my lord.
Heard Mr.
Yes, Google, my lord.
Lanka Council for the petitioner. Also heard Ms. El Hadi, Lanka Council, Lanka petition of PP, government AP.
PP can have instruction.
LCR call for, not LCR, huh?
CD, my lord.
CD.
The CD, the case there is called for, is not right.
Your Lordship, this charge sheet already charge sheeted, Lordship. It's annexure 24.
Where from?
Annexure 24, Lordship, their petition.
Hmm?
Annexure 24. Oh, sorry, annexure, page 24. Charge sheeted on 36/23.
Is the FIR, my lord. The three codes.
Page 24, Lordship.
FIR.
Page
FIR.
24.
This 24 the FIR. Type copy of FIR, my lord.
I think number 6.
Five. Good, good.
I'm so sorry, Lordship. I am
FIR. The case that is called for is still awaited.
Lordship. Lordship, I'm so sorry, Lordship. I was looking for the item number 6,
The
Lordship.
Council for the petition submits that
No, no, no.
the petitioner, sorry, the accused has been languished since
My
The
lord,
accused was
since
arrested on
12 October
12/10/2023,
23, my lord. Yes, my lord.
and since then, he has been languishing inside a custody. And today, he would be completing 180 days.
81 days.
In view of above, sorry, 81 days, 81
81, as on today, my lord.
81 days, and prays for some time to file IA for IA for release of the accused on completion of the statutory period. Prayer is allowed. List this matter after a week.
My lord, it will be too late, my lord.
Huh?
There will be vacation, my lord, for
So immediately after vacation, it will be listed on 22, 23, 23.
My lord, I have a respectful submission that I want to withdraw the bill.
You want to withdraw?
Withdraw.
Okay. Then, Mr. Gogoi, Land Council for the petitioner wants to withdraw this bail application. Ms. El Hagi is present, stop. This bail application is dismissed on being withdrawn with liberty is spread.
Yes, ma'am.
And they want to withdraw this bail application with liberty to file a press, if so advised, huh? Okay. Then this bail application is dismissed on being withdrawn with liberty is spread. That will be better.
Yes, ma'am.
Since completed.
Yes, ma'am. Once you read, thanks.
Right.
Okay.
Yes.
May I Lordship? This is bill application under 439 for this
Here also it appears that the case diary was called for and not yet received, it appears.
Uh,
Have you
lo-
received, you have received the case diary?
No, Lordship, not yet.
Lordship, it's, this has been second hearing where case diary has been called twice.
Bail application?
Yes, in this case. And
No, when? Second time,
before that, before that,
Yes,
once LCR was called,
LCR?
LCR, lower court record.
Then why the case diary, if it has been, if the.
On first day, on first hearing, the case diary was called, but subsequently in next date, it has been acknowledged to this court that it has been charge sheeted. Therefore, lower court record is needed. So lower court, even apart from that, in petition also, that copy of charge sheet is also enclosed in this petition.
Is it?
Yes, I enclosed this charge sheet.
Call for the scanned copy of the record.
Yes,
Which court?
it's special judge NDPS UPIA. Yes, UPIA only.
Why is taking time?
And this is third hearing now. But all record are annexed there in petition.
Only 28.3.
Yes,
So I think that was 28.3.
28.3 and subsequent,
Copy. Was communicated. Record not yet received.
We call the LCR through registry, Lordship.
Yes, but then the registry, the records not yet received.
Lordship. Yes, some more time may be given, Lordship.
Can wait for some more time.
Lordship,
Some time for communication,
it's this,
although it's very near, but it's far. When you follow the official procedure.
Lordship,
will communicate.
Lordship, may I apprise this court? It's been 377 days and all means co-accused has been granted
What is
bail.
the status of the case there, whether the
Uh,
charge framed against the accused? Have begun?
Still, trial has not begun. A charge sheet has been filed. It's been 239 days, charge has been filed, but still it's stage of the consideration stage, charge sheet consideration stage. Now, the bail was rejected in that special judge UPIA. Based on that, the remaining, some of the alleged accused are not attending that consideration of charge sheet. That's the only ground.
21B
Yes, 21B. And
and 29 of NDPS, or probably. Then this is,
and
or I think probably this is 21B and 29. What is the statutory period, 180?
yes,
Then how many days he has been inside?
376 days
376 days.
and 239 days after charge sheet. So
So how many accused were there altogether?
in this Chimpu PS, 2 only. And all that contraband thing has been seized from that another alleged accused, not from,
He is also inside.
no, that another alleged accused is,
He
has
been
already
indicted
got
on bail.
bail. So all those contraband has been seized from the vehicle of this,
Okay, he was granted, he has been granted bail and then your bail has been rejected.
yes, yes.
So there must be something against.
No,
you.
initial stage, he could not afford this, means in that special court, I'm not the representative of this alleged accused. Just I'm filing for the first time before this honorable court after subsequent bail rejection.
See, while granting bail to the co-accused and your bail has been rejected, must have been considered.
Lordship, I will satisfy this honorable court that
What is
this
the
section,
The ground you must have taken there, what is the new ground you have taken? Which
yes,
have you taken
new,
there?
yes, new ground is, bail ground is in page number 5. Page number 5.
Have you annexed the bail rejection? order?
Yes, rejection order is annexed there. Page 48, bail rejection order. And bail rejection or means ground is very simple that if that co-accused is not coming for this consideration of charge sheet, then this alleged accused will also not attend if this alleged accused has been granted bail by that court, being prayed by and objected by public prosecutor only. So that was only the ground for the rejection of the bail.
Okay, normally what happen is that in the trial court, after CC, you press for CC. After CC, after consideration of charge, probably this court will release. Because since the another accused also, after obtaining bail, is not appearing. and
Yes, Lordship.
The learned judge is apprehending that he may also not be, but that may not be the reason for rejection.
That's the reason it's there
It
in
is always
order.
better you press for the CC. And then, but.
Lordship,
so
for
far as-
CC,
So
it's
far as this bail application is concerned, we are waiting for the record. So unless we officially we receive the record, see the records from the trial court, then it will be difficult. We have to consider on basing on that only.
Lordship, I've annexed all the record in this petition.
Maybe.
And interesting is that
And annexing and the
And-
records received from the may be different. We have.
Lordship, interesting part is that it's been 239 days and there had been 6 sitting for consideration of charge sheet.
Next day is fixed.
Next date is, I think next date is in 3rd May.
May,
Yes.
not very far away. Then insist that the charge may be framed against the present accused.
In absence of co-accused.
Let the charge be framed against, in absence of, when the agent went, because against this co-accused.
Lordship,
They must have issued a bailable or non-bailable warrant. Or must have been or declared absconder also, because 6 times if you remain absent, definitely.
Lordship,
that is the step.
Lordship, I will apprise this. This co-accused has been absent for last 2 appearances, and she has filed her JIMA application for vehicle from where that contraband has been seized. So that's one of the prima facie, though all the contraband and vehicle belongs to this co-accused.
That the trial court will consider.
So
Anyway, so let us fix early date, and then you also obtain instruction.
because it's been subsequently same,
It's not very far away.
yes, it's nearby only. So dead, Lordship.
Heard Mr. Al-Keeper, line counsel for the petitioner. Also heard Ms. Al-Hage, line counsel, line additional people for the state of the case record is still awaited. The registry shall issue reminder for the case record. List this matter.
In within a week, Lordship.
After a week. Within a
With-
week, it may not be possible.
After a week,
After a week.
date may be fixed, Lordship, date may be fixed.
No, unless the case record is received. Fixing would be. little
Lordship,
bit-
it's been 3rd time that record has been called by this
After a week.
after a week.
Yes.
So in this regard also record has been called, whether it's available or not.
Okay, this I think is the connected case from the arising out of same case.
Actually, the fact is that, Lordship, in both case, this instant alleged accused is not involved. And nothing has been recorded from this instant.
This is also UPR,
Yes, same.
similar order, huh? This is also record not yet received, huh? Party also, and only the case number will change, similar order. And this also will be listed after a week. This is here also scanned copy of the,
Lower court record.
so that scanned copy, huh? Say, because the trial is going on, it will be scanned copy of the record, huh?
NCR
Right.
Lordship, lower court record.
Scanned copy of NCR. Same. Okay.
Obliged.
Highly obliged.
Yes.
My lordship, this is my first appearance, lordship. I need 3 weeks time for file my power and
For
meantime,
respondent?
lordship,
Okay.
I may be allowed to
Who
file.
appeared for the petitioner? No one appears
No,
for the petitioner. No, no, stop. Mr.
K. Lawland, lordship, on behalf of G. Lawland,
This is first time.
lordship,
Okay. So you have not yet filed wakalat nama.
no lordship,
Would appear on behalf of the respondent number?
1 lordship,
How many respondents? Okay, respondent number 1. Mr. Write his name. Your name also, okay, would appear on behalf of the respondent number 1 and praise for some time.
3 weeks time, lordship.
Okay, praise for 3 weeks time. So the prayer is allowed. List this matter after 3 weeks. Okay. Mr. Hage is also appearing on behalf of the state. Earlier you appeared. Okay, okay, wrongly reflected. Okay, this is after 3 weeks. Huh?
Obliged.
Yeah, Your Lordship.
Yes.
Your Lordship, I'm for the petitioner here in this case.
Hmm. Who appears for the respondent?
Your Lordship,
I'll be appearing item number 11 to 15, Lordship, all are connected matter.
Okay.
Basically, Lordship, this is a title suit is going on there in CGM or civil court. SEPA, Lordship, and they have, because they have come for honorable.
For non-acceptance of the written statement.
Yes, Lordship.
On expiry of the.
Yes, 90 days.
statutory period. Okay. So, what is your prayer now?
So I'll be appearing for respondent number 1, Lordship. They are the private.
First time?
Yes, this is first time. I filed my wakalat number, Lordship.
Okay.
Lordship, this matter also like, instead of keeping this matter pending here, Lordship, let the matter decided there. This matter can be remanded back if like, by imposing some fine upon the petitioner, that is the defendant there.
Allowing the petition.
Yes, Lordship. Okay. Because the merit has to decide there only, Lordship. This is a like a title suit.
Hmm. So you are representing, how many respondents are there?
Respondent, Lordship, they have made, rest are performer respondent, the additional deputy commissioner, district
Okay.
land management.
The challenge. Let me try, just. Heard Mr.
E. Menjo, Your Lordship.
Planning Council for the petitioner. Also heard Mr.
V. Jamul also.
Planning Council appearing for the respondent,
1, Lordship.
respondent number 1. Para. Since this is in the order column. Okay. Para. Two. By filing this application under section 227 of the Constitution of the India, read with section 115 of Code of Civil Procedure 1908. By filing the civil division petition, Code of Civil Procedure 1908, the petition put to challenge the order dated 38/2023 passed by the learned civil judge senior division, the learned court of civil judge senior division, Sepa East Kabeng, Arunachal Pradesh, in title suit number 09/2023, under section under section 34 Specific Relief Act 1963, read with section 9 of CPC. Stop. Stop. No, CPC. By the said impugn order, by the said impugn order, the learned court, while observing that since the by the said impugn order, the learned CJ passed the following order within an inverted comma, since the written statement is not yet filed within the statutory period of 120 days, this court is inclined to proceed the case without written statement. Accordingly, the case is proceeded for document and issue. Bracket close. It is submitted that that the appellant respondent had given a plausible reason for his failure to file written statement on time or within a stipulated time. And in fact, the petitioner respondent had already had filed a written statement on 30/08/2023. And the said written statement was returned on the ground that it was illegible. And on the ground that some documents were illegible. Under the circumstances, the learned court below ought to have given an opportunity to replace the illegible document with a legible one for dispensation of justice. It is further submitted that by although the provision provides for filing of the written statement within 120 days, but it doesn't mean that the written statement could not be filed after 120 after expiry of 120 days of the receipt of the notice in a suit start. The learned counsel for the petitioner further submits that he has a good case and the balance of convenience is in his favor. And as such, pray for allowing him to file written statement, pray for direction to accept the written statement. You have already filed. You have no idea.
It was not received.
From the order, also it reflect that the order, it's ready, only just the documents illegible, so it hardly take, even not even like, only they just, since there are 5 cases pending against him, in the order, why they couldn't file the prayer made by the defendant, that is, petitioner advocate there. They're ready with, but they have not filed because
Not
of,
to file. Okay. Allow to accept the direction to allow to accept the written statement of the petitioner respondent. Start. Madam. Mr. Krishna, learned counsel appearing on behalf of the respondent fairly submits that the fairly submits that he has no objection if this petition is allowed with, with the condition, by imposing some fine upon the, petitioner. huh? There is also some, I think, ruling that a sale filed within 90 days, it doesn't mean that it's statutory, compulsory, but it is in the acceptance is a discretion.
Yes, Lord.
Even after that also, it can be extended actually.
Yes, Lord.
So that is there.
It
You-
says
do
90
you have a
days.
ruling? No.
Oh, I've not bought that lot, but it says
Okay.
90 days, but they have taken here 120 days.
No, 120 days, that's of course, by any means within 120 days. But even after 120 days
Yes, Your
also,
Lordship, it's always discretionary.
discretion is there.
That's why, Lordship, I'm
So
not
because
opposing to it.
some, because of the, of course. So here they say the plausible reason, or in fact, they have also filed.
Yes.
So if that is accepted, then probably he has a reason. So only because, the documents were not legible.
Yes, Lord.
So can be granted, no? So. No, any record was called for. Record was called for, noted, huh?
Not.
Record
has
probably
not
was
come.
called for.
No record was called, Lordship, like, the way they win the title suit was state, Lordship, that is by order 19 of
Okay,
2000.
then this is probably this, yeah? Okay. I'll give that the ruling later on, huh? So, in view of the above, in view of this, hard vote the land council for the parties, in view of the submission made above, and the decision of the above case, huh? I'm of the view that this petition can be allowed. Allowed, huh? Accordingly, the accordingly, the impugned order dated 38 2023 passed by the Learned Civil Judge Senior Division SEPA in title suit number 09/2023 is hereby set aside. The petitioner respondent shall be allowed to, as a result, the petitioner, the respondent shall be allowed to file his written statement in the title suit number 9 of CPC. No, the petitioner is, okay, allowed, huh? The petitioner is directed to file the written statement within within, since it is election, within 10 days from today.
Yes, Lordship.
Within two weeks, within 2 weeks.
Also, since Lordship, they have
Since
stated,
holidays,
Lord Court, Lordship, there is no holiday, only we have 1 day holiday.
Okay, then, but.
10 days will,
Okay, 2 days, 2 days, 2 weeks.
2 weeks,
huh?
Lordship. Lordship, a time frame may be given.
Okay, till 26.
Till 20, okay.
Okay. Till 26. On a condition that the petitioner pay a fine of rupees 2,000.
Paid today in the.
Pay
in the-
to be paid to the sorry, petitioner, not petitioner, the respondent petitioner. Plaintiff,
Respondent,
plaintiff. So, respondent plaintiff petitioner shall be allowed to file written statement within 26, on the condition that the petitioner deposit a sum of rupees 2,000 is a fine. The fine so deposited by the fine so deposited by the petitioner respondent shall be paid to the respondent plaintiff. Okay. That will do with the above this CRPC stand allowed and dispose of.
11 to 15.
11 is same for all.
All, sir, yeah.
And only the
Only
is-
the name.
Okay. Name will be different. Okay. 11, 12, 13, 14,
15.
up to 15.
Yes, Your Worship.
Okay. Yes. So what about other 26 minutes? Yeah, 23, 23 also. Similar.
Lordship in 23, like, I'm for the petitioner here.
Okay. Okay, nothing like that. So, look, adjournment. Anything?
Lordship,
Someone mentioned here this morning, verification? Okay, this is one, okay, at 2.
Lordship,
Yes,
item number 23, Lordship, that may be fixed for this.
okay. When do you want?
Because he will take not less than 30 minutes and I will also take not less than 30 minutes.
Which one?
Item number 23.
23. First of May. Mr. 23. Who is for the petitioner?
He's for the
Jamo, Land Council for the petitioner. Also heard Mr. Rinchi L. Tungon, Land Council for the respondent. Is prayed for by the Land Council for the party. List is matter on
1st of May.
1st of May. Okay. Rest at 2.
May I please your lordship? Lordship, 439 application in Simpu PS case number 16/2024, FIN page number 10, lordship, Annexure 1, Annexure A. May I read?
Just a minute. Please.
Page 10, Annexure A.
Okay.
To be mentioned below as per actual details. One RRU has been stolen from ATC Tower India American Tower Corporation. This pole tower has located Gopur nearly near to Jurut. The RRU has been
This is addressed to?
addressed to officer in charge Shimpu
Chimpu,
Police.
it's
Yes,
Chimpu.
lordship. And by the one Shibu Kataria,
Tower
Ramesh
said
Kataria
has
of
been
Puthli,
stolen.
lordship. The RRU has been tapped on yesterday afternoon. Our team has been reached at the site after information got.
Just a minute, where are you reading?
Lordship.
To be mentioned, okay, below.
Yes, lordship.
1 RRU has been stolen, okay. Yes, start from this 1 RRU.
one RRU has been stolen from ATC Tower, India, American Tower Corporation. This polo tower has located Guwahati near to Jorot. The RRU has been thefted on yesterday afternoon. Our team has been reached at site.
Theft on yesterday.
Yes, madam. Our team has been reached at site after information got from the Airtel field engineer Debasis Das. The pole tower placed at second floor of building. We have also give some photos and videos logic. This is the affair. It was registered on 23rd to 2014. 2014 and arrested accused person were arrested on 25 to 2014 logic. I have an exact forwarding report also.
25?
25 to 2024.
Okay,
Today is 46 days logic.
okay.
And annexer C logic, page 18. The this article, the theft article already recovered by the IO logic from
Annexure
ISBT
C.
Guwahati.
Annexure C.
Yes, logic. Annexer C. Caesar memo under section 120B logic. CRPC logic.
Page,
Simple 18.
okay. These
Simple
were,
case number so and so, so and so. Place of seizure ISBT Gorsuk, bus stand, Guwahati. Date and time of seizure 25 to 2024 at 1447 hours. Seizure on being produced by give name and address. One being recovered from Iceland Travels bus bearing registration number AS29C 0775. Particulars of article 6 remote RRU bearing CL number so and so. There are 5 RRU bearing a CL number 3574559 lots. As until that, the accused person are in behind the bar lots.
it was from the bus.
Yes, Lordship. One Iceland name Iceland Travel, bearing registration number AS29C 0557 Lordship. ISBT Guwahati Lordship.
This tower belong to,
Lordship.
these all material tower, these belong to
Belongs to Geo Lordship.
Geo.
Yes, Lordship.
Who is this informant?
Lordship.
Who is this informant?
Informant is the Shibu Katoria Lordship.
No, who is
He
he?
is the site manager, field engineer Lordship.
You not mention his official,
No Lordship, in the affair Lordship.
not mention his, not mention his official designation and all, so could not be.
Yes, Lordship, not in the affair also. Near Basinal office. Site technician Lordship. Forwarding report, page number 15.
So this was stolen from the top of the building.
Yes, Lordship.
The tower was still functioning. Or it was an abandoned one? tower?
Abandoned one. Lordship.
Abandoned?
Yes.
Where do we find the name of the accused? Down below,
Yes, Lordship, in the forwarding report also, Lordship.
given.
Uh, Yes, Lordship. Page number 16, Lordship. Accused person, namely Sri Ankur Tasa, cell number so and so, was identified. Son of Jivan Tasa, Lays Rabor Sapori, POPS Narayanpur, District Lakhimpur, Assam, and
Only
Sri
one.
Kumar Kumar.
Only one was arrested,
No, Lordship, there are 4 accused arrested.
4 accused.
Yes, Lordship.
So this application has been filed only for
The
one.
application for 2 persons, Ankur Tasa and Bitupan Tasa, they are blood related brothers, Lordship, having his own father.
They have filed separate bail application
No, Lordship.
in one bail application.
Yes, one Lordship.
Will it not be difficult for you?
No, Lordship.
Yesterday also in one bail application,
Yes,
case was different. One was main accused, one was just, he was arrested on suspicion.
yes.
Condition imposed
Yes.
was 1 with 2 lakhs. And then I would have imposed this to another person, some around 10,000, but then he had to pay 2 lakhs now.
Yes, Lordship. No problem, Lordship.
No problem.
Because both are arrested in connection with same case, Lordship.
Okay.
And brother also, Lordship.
Hmm.
Father is,
But when there is a slight difference also, it's always safer to file separate bail application.
but is there
Because
any mandatory in also, Lordship?
Hmm?
There is no necessary or mandatory for separate bill.
Not mandatory, I'm saying
Yes, Lord.
safer.
Yes.
For you, safer for you. Okay, so yes,
Lordship,
state.
Lordship, here, Lordship, the ground of rejection, Lordship, in the order dated 8/4/24.
8/4?
24, Lordship, this is, day before yesterday only, the bail was rejected before the JMFC.
Bail, you applied bail before the trial court?
JMFC, yes, Lordship,
Okay.
page 22.
How many days he says, you said he has been inside the custody?
Today is 46 days.
46 days. He
Yes.
applied bail before the trial court magistrate.
Yes, Lord. JMFC, UPL, Lordship.
Okay, what is the ground for rejection?
Ground rejection,
One prime
Lordship,
accused.
prime accused is absconding, Lordship, and the revealing only the investigation only, Lordship, the examination of the accused, Lordship, during investigation only the prime accused, which is absconding, it can be revealed, Lordship. So here custody interrogation is still needed, Lordship. And here, Lordship, the accused, Lordship, they are the members of some gang operating interstate thieves, Lordship. So
Oh.
it kind of change, Lordship. So at this stage, if he will be, Lordship, outside the this investigation, that it can be, Lordship, hampering the investigation, Lordship.
So at the moment, we can call for let us see, because absconding of the co-accused may not be the reason for further.
Lordship, then CD
If
may be
he-
called for,
If
Lordship.
he has already been examined, that may not be the reason for his further detention.
We call
Call
for
for the
CD, Lordship.
CD
Lordship.
to assess.
Police have already remanded the accused person for 8 days, Lordship. And so far as now, long as investigation might be completed. And today is 46 days. No need for CD or for any further interrogation or further.
But then you see,
Yes,
only,
Lordship, page number 70.
only yesterday, or the day before
Day
yesterday
before
only,
Yesterday.
your bail was rejected on merit. What is the new ground you have taken this time before this?
No,
court?
Lordship, length of detention, Lordship.
Hmm?
Length of detention, Lordship, and already the RRU.
That contention we have already made before the Lanark trial court,
Yes, Lordship.
Lanark JMFC court.
Yes,
This contention we have already made.
yes.
And considering your submission and the contention made in the petition, your bail was rejected. Now my question is, what is the new ground you have taken this time?
No, that's.
On the same ground, the bail has been rejected. How do we reappreciate? On the same ground, how do we grant? On the same ground, your bail application has been rejected already by the Lanark JMFC. So on the same ground, how do we grant? How do you expect this court to grant on the same ground?
No, Lordship, that section is 379 only, punishment in 3 years only.
That is what I'm saying.
Yes.
Punishment in the JMFC, the punishment was more. It's all the same. Punishment all the same. Date, that what he spent in inside the jail, custody, police remand, or the judicial remand, it's all the same. The contention you made for his bail, for grant of bail, is all the same. On the same ground, learned judicial magistrate first class has rejected day before yesterday only. Now, what is a new ground? Unless you take the new ground, on what ground do you expect this court to grant bail to you? Unless there is a new ground.
Police said only on suspension, arrested by accused person, Lordship.
Same thing you have already submitted before the learned judicial magistrate first class at a time of bail hearing. After considering that only, finding his involvement, prima facie involvement in the case, in the commission of the offense, and then finding that his grant of bail would not help or would hamper the further investigation of the case, the learned judicial magistrate first class has already rejected your bail application. How do you expect this court to grant on the same ground? You want this court to say that the learned JMFC has passed an illegal order by rejecting? Are you challenging the bail order?
No, Lord.
Then, on what ground do, and what ground? What
paid
ground?
the pair only on the ground that JMFC have reject my pair, and only on the basis of length of detection, I have filed it before liable court, because JMFC
Same thing. What I'm saying is the same thing you have submitted before the learned JMFC. Day before yesterday only, it was rejected.
Yes.
What is the new ground you have taken for filing subsequent bail application before this, immediately after rejection of the bail?
No, this honorable court have the discretionary power to grant a bail.
That is there,
Yes,
but
Lordship.
discretion, you want this court to use the discretionary power against the JMFC. JMFC has appreciated the submission, appreciated the evidence still found by the IO of the case. Thereafter only rejected. Immediately you have filed without changing any status of the case. What new ground, what new development has taken place thereafter within this 1 day? Unless the new development taken place on the same ground, how do we reappreciate? How do we grant on what ground, what basis?
JMFC rejected our pair only on the ground.
Are you challenging the bail order of the JMFC?
No, Lord.
Then, on the same ground, how do we grant? One judge just rejected. Another judge, how do you expect another judge to grant bail? On the same ground. Well, and you say, admittedly, you have not taken any new ground, no new development. The ground could be that 60 days expired. After, of course, waiting for some days.
That's why I'm telling
You have completed 46 days. After 14 days, if you file, then of course, the status change. Some new development taken place that he has already spent 60 days, statutory period over, that could be the ground. But then on the same ground, what has appreciated by the JMFC, how do you expect this court to reappreciate the same thing? And on the same ground, grant you bail. This is not the case. Something new development has taken place, or something the JMFC has not considered. It is a case where JMFC has considered before granting bail. You should understand, as an advocate also, you should have understood that to file the subsequent bail application, at least you need a new ground. You have to satisfy the court that this is a new development after rejection of the bail. And then you are disturbing the investigating agency, calling the CD time and again, immediately, subsequently, within 1 day. Day before yesterday.
I am coming before this honorable court only on the ground that this is the court where that have the discretionary power to grant a bail.
JMFC also has a discretionary power. Bail, you see, every court has a discretionary power to grant bail. But then you have to satisfy the court that immediately after rejection of one court, your bail application by one court, some new development taking place, some new changes, or something that the other court has made some mistake. You have to satisfy something at least. So, what do we do? You file after some days, some time. There is a prima facie case. Admittedly, he has stolen and he recovered also. That statement you can't change now. You have already stated here. It was recovered from him, his possession.
Not his possession.
Hmm?
Recovered from one Iceland travel, which is a night super or day super from ISBT Guwahati. And I am the owner of a Bolero registration number A01FR 9116. And the accused number 1, accused petition number 1 is the owner of the Bolero.
You disown the property recovered?
No, not property. I have made in the petition also. I am the owner of the Bolero pickup, pickup. By registration number 01FR 9116. And petitioner number 2 is the younger brother of the accused number 2 Lordship.
See, all of them are involved. Made an observation.
And only on the basis of, purely suspension, I was arrested. Both are arrested by the IU Lordship. And one Gunakanto Kaur is the prime accused.
They are gang member.
One Gunakanto Kaur is the prime accused, and he hired my Bolero to use his hired process.
From Assam?
Yes, Lordship.
See?
I am not directly indirectly involved in the alleged offense, Lordship. I have mentioned in my pregap, Lordship. And page number 4.
Extension of judicial is not a valid ground.
Para 5, Lordship. Last step.
Just a minute, huh? Anyway, you produce a scanned copy of case diary?
No, sir.
Okay. Mr.
G. Fukan.
G. Fukan, Land Council for the petition. Also heard. That's right. No? Land additional people. Take the baby. Start. By filing this application under section 439 of the Code of Criminal Procedure, 1973, the petitioner, who is the petitioner?
Suren Tasa, Lordship.
Who is he?
Who is the uncle of the accused person, Lordship.
Seek for granting of bail to the accused. What is the name of the accused?
Ankur Tasa and
Name of the accused?
Yes, Ankur Tasa and Ritupan Tasa. First title, Lordship. Page number 2.
Name of grant of bail to two accused persons, namely Ankur Tasa and Ritupan Sacha. Who have been arrested by the Chimpu police in connection with Chimpu PS case number 16/2024 under section 379(34) of the Indian Penal Code. Issue notice returnable by call for scanned copy of the CD. Since Ms. El Hage accepted notice on behalf of the respondent, no formal notice need be issued. Notice be issued. List this matter on after 4 weeks.
How many days, Lordship? How many days? List after?
How many days it will take?
Lordship,
Chimpu
Chimpu,
only
it can,
is 2 weeks. When?
just 2 weeks, Lordship.
That will take, Lordship, 22.
22.
Otherwise, I am to withdraw my application, Lordship.
Okay, when the 60 days expire?
As because 379, there is no such mandatory, Lordship.
No, not minute. I'm just asking.
Yes, Lordship.
Hmm.
Then another 14 days.
14 days.
23 like Lordship, 23rd.
23 have a matter and another court, Lordship.
Okay, so 22.
22.
Because Lordship, till Lordship 20 holiday Lordship. then-
Up till 20 it is holiday.
Yes, Lordship.
Here in this court.
Yes.
Now next is 22.
22 Monday Lordship, if we have received or not.
On
Lordship,
Monday they will just receive.
Yes, Lordship.
Tuesday it will be able, they will be able to place it.
Yes.
23 after 22 any days. You take that. You give that. After 22 any day. Okay. This is paid for by the land council for the party. This is matter on 25 is 25 holiday or something. Some mark. No.
No, Lordship, no.
Okay, 25. Okay, blue mark. On which date the landed additional PP shall also produce the status quo. Sorry,
Status report of the investigation.
case. Okay.
Obliged.
May I please, your Lordship, I have to just know from your side, Lordship, has been made. Is there any mandatory for count any ground for?
Not
regular-
mandatory, not mandatory. So it will be difficult
If
to
it is
convince.
anticipatory, then there will be definitely
It will
ground.
be, it will be difficult to
And
convince the
petitioner
judge.
court is not grant, not reject my prayer. I am just filing this petition.
No, that is why I am not rejecting. I am not rejecting. So it's not mandatory, but then it will be difficult to convince the judge that on the same ground, you can't expect another judge to grant. One judge rejected
Lordship.
by appreciating the fact and circumstances of the case, just rejected yesterday, day before yesterday. And then another judge, how do we grant? The same thing. Nothing changed.
No, Lordship.
No, okay. Any other case?
Obliged.
Yes.
Your Honor, I had mentioned for adjournment in the morning for this.
Oh,
matter.
yes. Why you did not
It happened at the end.
put a mention after, in the last? So, when do you want?
After 2 weeks, Your Honor.
Hmm?
After 2 weeks.
After
I'm
2 weeks.
appearing on behalf of Mr. S.K. Deori,
Miss,
T.Y. Bhutia,
yeah, land counsel for, you are for the petition,
for the petitioner.
counsel for the petitioner. And Miss,
Your Lordship, I'm appearing on behalf of Mr. P. Tapo,
okay, also heard Miss. You are Miss,
Tirini.
appearing on behalf of Mr. P. Tapo, land counsel for the petitioner.
Your Lordship, we
Sorry,
filed
respond.
Bakalat Nama today.
You are
I'm
filing.
appearing for the first time.
Okay, who submits that? They are filing Wakalat Nama.
Filed already filed.
Wakalatnama.
For the sole respondent.
Some is that sole respondent.
Yes, yes, Your Lordship, sole
Some is
respondent.
that they have recently been engaged and filing wakalatnama today. So, in view of the above, list this matter, in view of the above, and as prayed for by the land council for the party, list this matter after 2 weeks.
2 weeks.
Okay.
Much of.
You could have mentioned in the last moment, huh? Finish.
ডিসপোজাল একটু লাই দেবো নাকি না লই যাবো আজ টাইম পাওয়া না আইডিয়াটা কম্পাইলার বনাই দেবো না আইডিয়াটা বনাই দেবো আজ চলো রেডি করে রাখি দেবো লড়ার মতো বলবো
ধন্যবাদ।